Hi there. Looks like we are live. Eureka Cole, the church attorney here. I am jumping in to share with you because I've gotten a number of questions, and frankly, I'm dealing with an issue today that is really critical for churches to be aware of, and I think is also very impactful overall for how church is going to be done going forward. So I'm here to talk specifically about the IRS issuing a significant reinterpretation of the 1954 Johnson Amendment that now allows churches to officially endorse political candidates. And I want to hear from you. I'm really eager. Drop in the comments, please, what your thoughts are around this. I definitely have some questions. I have some concerns, and I'm going to lay it all out here. So again, we're talking about this new IRS regulation or revision of an existing regulation around churches being able to endorse political candidates. So let me take a step back so that we can move this process forward so you can see the significance of it, right? So what has changed? The IRS now considers political endorsements by churches to their own congregations delivered, quote, in connection with religious services, end quote, via normal channels as exempt from the ban on political intervention. What we know is that tax exempt organizations, in exchange for the significant benefit of being tax exempt, right? There are regulations, there are do's and don'ts. There are things that tax exempt organizations can do, and there are things that they can't do, right? So they can't, prior to this most recent ruling, be involved in political endorsing or speaking in opposition to an existing political candidate, right? So churches would be able to provide educational opportunities, right? You can invite candidates from both sides of the line to share their platforms, their thoughts, their intentions, right? But a church couldn't stand and say, we are for candidate X and we are opposed to candidate Y. Well, that's the significant shift here. So essentially, the IRS now considers this political endorsements to be something that is not in line with political intervention, which I think there's many who are examining the text who would find this to be a significant misstep. Essentially, sermons or pulpit endorsements are treated now like family discussions as opposed to campaign activities. So what it means, churches and religious nonprofits can now legally endorse or impose candidates during services without losing their tax exempt status. Now, there has been a litany of activity that's been prohibited, right? So, of course, churches could not prior endorse. They could also not fund political activities, things of that nature. And so we are looking at the fact that non-religious nonprofits like charities or universities, this restriction remains in place for them. So universities, let's say hospitals, other kinds of tax exempt organizations, they still are not able to endorse candidates. So that also strikes me as incongruent, right? So the rule before was every tax exempt organization, you can't be engaged in this political activity. Now it appears that the IRS has exempted churches, but not other tax exempt organizations, right? So that prohibition is still in place for them. And this really comes from something that's known as the Johnson Amendment. You might see me looking down because I want to make sure I give you precise language. So the Johnson Amendment was enacted in 1954. It was authored, many bills have the name of the author, right? It was authored by then Senator Lyndon B. Johnson. It's embedded in Section 501c3 of the tax code, like literally, see my book here? Okay, on the side right here, this book. Let me grab it. This is my church attorney's guide, thanks for the heart, on how to obtain, maintain, and protect your church's tax exempt status, right? Because I'm providing this direction about tax exemption and all the do's and don'ts. So obviously we'll be making updates as this information continues to come about. But it's embedded in Section 501c3, which is the tax exempt language in the Internal Revenue or the U.S. tax code. It prohibits, again, we're talking again about the Johnson Amendment. It prohibited all tax exempt nonprofits, including churches, from endorsing or opposing political candidates or being involved in campaign activity. Now, there is a certain reality that historically enforcement has been spotty at best. There were organizations that specifically would have a Sunday dedicated to political activity in church with the hope of being baited by the IRS so that this issue could be litigated and addressed. Executive actions by the first administration of the current president signaled leniency, but Congress never repealed the law. So now we see sort of a secondary way of attacking this particular law. So we are talking about specific implications going forward. The judge approves the consent judgment by the IRS to be legally bound and not to sanction the particular church or suing over in-church endorsements. What we are seeing from a legal standpoint or considering is that this ruling could set a precedent where candidates perhaps rely on churches even more strongly to provide endorsements and to find another loophole, I guess, where churches could become a tax subsidized political system, right, without any public disclosure, which is what all existing PACs, right, if you're familiar with that term, are required. So let's talk about specifically how this is like the roles and boundaries. I just want to go through this really quickly. So what we understand to this point is that pulpit sermons endorsing a candidate, check, that is now presumably allowed. Political ads paid for by the church, again, that's still, I think, risky behavior. I would not encourage a church to lean into that, certainly until we get a lot more clarity from the IRS. Mass emails or public rallies by a church, again, I think that's risky behavior. We don't have any language to date that would be allowed. Religious teachings, including politics, I think we can pretty much say that is allowed. So sermons endorsing a candidate, I think that's allowed. Religious teachings that include politics, I think that's allowed. Political ads paid for by a church, probably not. Mass emails or public rallies or any other kinds of on-site activities that are generating more, I guess I would say, more support, active support in the church, probably that's risky behavior. But we're going to continue to watch this. We're going to continue to keep our eyes on it. And I just want to just say, I'm also following the reactions. Again, share in the comments what your thoughts are around this new IRS repealing of the Johnson Amendment, where churches were prohibited from sanctioning or opposing a political candidate. Now, as of this week, that is allowed. And so supporters, specifically some evangelical leaders, are celebrating it as a win for religious and free speech rights. Critics, on the other hand, say, especially legal scholars, nonprofits, even some other religious leaders, say that it could create tax subsidized political pulpit, right? Where the pulpit is now for sale to political candidates, which I can't imagine we would see as a good thing. So let me just wrap this up. Crucial takeaways. Number one, yes, there is a new IRS regulation. It's a carve out to the Johnson Amendment, effective as of July 7th, which is when the court ruling came in. There are new roles that are allowed. The pulpit endorsement of candidates by churches to their congregation is now allowed. But traditional political campaigning, ads, public communications, lobbying, to our knowledge, as of this time, that's still prohibited. We're still, as it relates to next steps, still awaiting judicial approval The long-term status and the impact of this obviously remains to be seen. I want to invite you to continue to learn more, to come alongside with me and other leaders who are providing critical insights at my Church Law and Leadership Summit, formerly known as the Church Compliance Conference. It has been rebranded to really focus the broader breadth of the work that we do. So it's the Church Law and Leadership Summit. We'll drop the information in the comments on how you can attend. It's virtual, so no matter where you are, you can definitely attend. We'll be able to get a bit more in the weeds around this. It's in September, so that'll also give us some time to see how more of these things play out. I'd love to read your comments and your thoughts on this critical change. So thanks so much for being here, and I'll look forward to seeing you more. Bye.